Today we are going to discuss about two basic topics of company law. The first topic, what is a company, and the second topic, the essential characteristics of a company, or can be called simply in a shorter version can be called as essentials of a company. So what is a company? A company is an artificial legal person. It's simply put an artificial legal person. Why it is called an artificial legal person? Here our emphasis should be put on the words artificial and legal person. As a legal person, it can own property, incur debts, employs people, and can become a party to the contracts and legal proceedings. And why it is called artificial? Because it can only exist as a name in the computer records of an ROC. So as a tangible natural person, you cannot touch it, but you can only feel its presence. That's why it's called artificial person. So the legal person is considered as having the same legal rights and obligations as a natural person. Here you should understand the company is only having the legal rights but not the fundamental rights. However, it can put into the legal relationship by humans managing it. So what are the essentials of a company? So before going into the essentials of a company, we should understand a company can also be called as a body corporate. As per the definition of company in Companies Act 2013, which is found at section 1 clause 4 subclause F, it will start with any such body corporate. So what is a body corporate? So if you can look into that, a body corporate can be analyzed into two aspects. One is body and another is corporate. Why it is called a body? Because it is an association of persons, an internal aspect of a company. And why it is called a corporate? Because it is a separate legal entity from its members. It is an external aspect. So as an externally you can see a company as a separate legal entity from its members, but internally if you say it is an association of persons. So what is the most crucial advantage in forming a company? So the most crucial advantage in forming a company is those who finance the company will not have any liability for its debts but can take a share from its profits or assets. Case in point, Solomon versus Solomon Company Limited, 1897, Admiralty Code, page number 22. So in going into the essentials of a company, the main essentials of a company is members, shares, limited liability. So members, a person can become a member of a company by holding a share in such company. So what is a share? A share means a unit of ownership interest in such enterprise. So holding a share also gives an obligation to the person to contribute an agreed amount to the capital of the company. This agreed amount is called the share value. So once the share value has been paid, the person becomes shareholder or member of a company. And after paying of such share value, he does not have any liability to contribute any more to the company. This concept is called limited liability. But why a person have to contribute without any particular interest? So as the contract says, there should be a valuable consideration in return for any such kind of transaction or contract. So likewise in company, a person cannot invest in any other company without any financial gain. So a shareholder expects a financial benefit from the company in a form of annual distribution of its profits, and such annual distribution of profits is called dividend. So what is the other privilege for the shareholders? What is the other privilege for the shareholders? They can take part in the decision making of the company. Yes, voting in the decision making. So whenever a company needs any such kind of growth or expansion, or it needs new capital, or it wants to go for an initial public offering, it will go for a board meeting or annual general meeting, where the shareholders will be called upon to take a vote on particular action of a company. So next thing, share transferability. Share transferability is mostly available to the public companies, public limited companies, because in private companies it is almost restricted. So share transferability is another advantage in forming a company, and it is this particular share transferability in the ready market such as Bombay Stock Exchange and the National Stock Exchange makes it more lucrative to the investors, because the ready market of the shares in a Bombay Stock Exchange or National Stock Exchange will make it more lucrative for the attractive for the shareholders to buy or sell the shares of the public limited company. Okay, coming into the questions, can a director be a member of a company? Yes, directors can be a members of the company. Mostly directors are members of the company. And the second question, can a company be a member in another company? Yes. A company can become a member in another company, with certain exceptions to the subsidiary company and the holding company. A company can become a member in another company. So coming into the memorandum of association and articles of association, MOA and AOA, abbreviated. So what is MOA? MOA is considered as the Bible, yes, the Bible of the company, because it is a power source of the company. Whatever actions that the company wants to do, whatever the company businesses whatever businesses the company can do, whatever businesses the company can take part of, whatever the company can do actually, is all written in the memorandum of association. If at all it is not written in the memorandum of association, MOA, the company's act is considered as ultra vires. So what is articles of association? Articles of association is considered as a rule book of the company. It is the constitution of the company. It will delegate the power to the management. It knows the hierarchy. It will give the rules, a particular set of rules for the power hierarchy structure in the company. What needs to be done and what has to be done, the procedure for that particular things to be done. Everything will be written in the articles of association. If for a better understanding of articles of association, we can look into the particular rules of UK model rules of articles of association in the particular in the Google by typing SI/2008/32229. So the tripartite structure, coming to the tripartite structure and the principal agent theory. So the tripartite, why it is considered as a tripartite structure, and what is the tripartite structure that we are talking about here? See, the members do not have a direct authority to act as the company externally in the market. So what they do is they give the powers to the directors to attend to its daily needs and day-to-day management of the company. So the directors appointed will act upon the interests of the company and the members of the company, and try for the growth of the company. So this particular relationship between the members, directors and the company is called the tripartite structure of the company, and this forms the basis of the corporate governance. So, and coming to the principal agent theory, so members of the shareholders of the company can be considered as the owners of the company, and the board of directors are considered as the agents of the company. So This can be called a principal agent theory. But there will always be a conflict of interest between a principal and an agent. So if at all there is a rise of conflict of interest between the principal and agent, that will cause the fall of the tripartite structure, which will weaken the company, or which will make the company, which will drive the company into losses. So corporate governance reduces the risk of this conflict of interest to affect the interests of the company. So coming to the borrowings, for a company there needs to be many sources of finance. One is through shareholding, one is through giving by giving shares, and another is through borrowing. So borrowing is considered as important source of finance for the companies. The company will provide the lenders with a special form of security, such as floating charge at debenture, or a debenture with floating charge. Floating charge is nothing but a charge created upon the fixed assets of the company. However, this particular security cannot be given by the unincorporated companies. So coming into the insolvency and liquidation. So when a company ceases to function, its finances are insufficient to pay its debts, then the company becomes insolvent. And the procedures for this insolvency, when the company is to be declared insolvent, or the procedures where the company can be declared insolvent, it's all written in, is laid in the Indian Bankruptcy Code, Insolvency and Bankruptcy Code, actually Insolvency and Bankruptcy Code 2016, and Insolvency Act 1986 in UK. They can see, as per this particular acts, there is some certain procedures laid down where the company can be wound up, or they can try and rescue the company, or wind it up and dissolve the company. So this particular if at all a company needs to be rescued, what needs to be done and what are the procedures for that is all written in the IBC 2016. There are also procedures for winding up of the companies that are solvent but no longer needed, such as imagine a company in the 60s where thermal energy is very prominent source of energy, but later on hydel power projects came into existence. Now the thermal power projects are slowly becoming non-existent, and there are many new kind of renewable sources of energy. So what the thermal energy companies, they are solvent at that time, but they are no longer needed because of the technological improvements that have happened. So which are no longer needed needs to be winded up. So the companies which are solvent but no longer needed to be functioned are also in, are also winded up as per the procedures laid down in the Companies Act and as well as IBC 2016. So insolvency, the main topic here is insolvency and liquidation offers an opportunity to examine the director's role and responsibility in the company's failure. So it can be that the company's insolvency and liquidation, company, if at all it is going for insolvency or it is going for liquidation, it offers an opportunity to examine the director's role and responsibility in the company's failure. So coming into the question here, what is a vulture company or vulture funds actually? So this is a particularly a new concept which has been coming into existence in India in the recent days. So what are the vulture companies? Vulture company is a company where if at all insolvent company, or a company, if at all a company which is in the bad debts, which is having many bad debts, needed a bailout, this vulture company will purchase that such insolvent company at a very minimal rate and try and rescue it and make it as a profitable company, and then it will sell the company into the market, or it will just make the company sell the company into pieces, sell the company as pieces, such as its assets. It will completely segregate the assets, losses, and everything, and it will completely sell as per the market. Thank you.